Hello friends, in the series on the income tax cases, today we will discuss the case of SANJAY SUDAN versus Assistant Commissioner of Income Tax. This case has been reported in 452 ITR at page number 107. The matter has been decided by Delhi High Court and the date of the judgment is 17th February 2023. In this case, the assessee was an employee. For the assessment year 12-13, the assessee received the salary after deduction of TDS by the employer. But the employer did not deposited the TDS. That is why this amount of TDS was not reflecting in the 26 AS of the assessee. The department raised the demand and recovered this demand from the refund of the assessee of the assessment year 15-16. The assessee moved to the High Court in a writ petition by giving the plea of section 205 and the notification of the department issued by the Central Board of Direct Taxes of 2015, which says that if the tax has been deducted by the deductor and has not been deposited by the deductor, and due to which this amount is not reflecting into the 26 AS of the deductee, then this amount of tax cannot be recovered from the deductee. And for clarification of this section 205, the department also issued the notification in 2015, which is with the alignment of section 205, which also clarifies that tax amount cannot be recovered coercively from the deductee if the amount of TDS deducted has not been deposited by the person who is responsible for depositing that tax. Meaning thereby that the deductee does not have any control over the deductor. He is dependent on that. If he deducts the amount and makes my payment after deducting but didn't deposit that tax, so I cannot tell him to deposit the tax. So, for the benefit of the assessees, this provision has been laid down in Income Tax Act 1961 by the way of section 205 and by the notification issued by the Central Board of Direct Taxes in 2015, which both are in alignment and which says that there is no fault of the deductee if the tax is not deposited by the deductor, and if the department adjusts that amount from the refund of the assessee from the future years, then it will tantamount to recovery of the tax coercively. So, if we read section 205 in conjunction with the notification of 2015, that gives a clear indication that the tax cannot be recovered from the deductee if the tax has not been deducted by the person who is responsible for depositing the tax. If the tax has been deducted and it has not been deposited, then the assessee, who is the deductee, does not have any fault and he should not be penalized for the fault of the other person. For this, there is section 199 also, which says that the credit will be given only when it is deposited into the treasury of the government. But this section 199 will not come in the way of section 205 and the notification of 2015, and section 205 and notification of 2015 will prevail and the assessee will be given the benefit of the tax deducted by the deductor, whether it is being deposited by him or whether it is not deposited by him. Friends, this case is very important because these type of issues come very frequently that when the TDS is not reflecting into the 26 AS. But the main issue is that in spite of section 205, notification 2015 and a number of the judgments in favor of the assessee, when the assessee writes this thing to the department, they do not consider this request of the assessee. So the assessee has to move to the High Court by the writ petition. So it is not possible for every assessee because sometimes it may happen that the amount of the TDS is not so big, because there is a huge cost in going into the writ to the High Court. At the end of this video, once again, I am repeating the name of the case. The name of the case is SANJAY SUDAN versus Assistant Commissioner of Income Tax, and this case has been reported in 452 ITR at page number 107. The matter has been decided by Delhi High Court and the date of the judgment is 17th February 2023. Thank you, friends.